Well, welcome to the Greg Lastowka Memorial Lecture. Thank you for your patience. Greg Lastowka was a special person. I had the chance to know him in college and several places in life after that, and at every one of them, his brilliance and humility was so rare. He also stuck up for the little guy. And so just one example was a case that he brought in private practice called Intel v. Hamidi, where he represented a former employee of Intel who complained about Intel's employment practices, sent just a few emails over the course of 2 years, and Intel said it's the end of the world and our employees aren't working and our server's going to crash and all that. It's just all made up. And Greg was successful in getting the California Supreme Court to find that the employee should win because there was no harm here. So that's just one example of how Greg really stuck up for the little guy in a way similar to what the Federal Trade Commission does. And so we have honored Greg's memory for 5 years, thanks to the generosity of Ray Solomon, John Oberdeek, and Kim Mutcherson. Were able to honor Greg's memory. And then the last 2 years, when that funding ran out, Bill McNichol generously stepped up. And so we are able to continue to honor Greg's memory. And so today's lecture will be given by FTC Commissioner Rebecca Kelly Slaughter. Commissioner Slaughter is a graduate of Yale and Yale Law School. She worked in the DC office of Sidley Austin and then was chief counsel to Senate Majority Leader Chuck Schumer. Commissioner Slaughter has worked to build a consensus for progressive vision. She believes that the FTC's two missions of promoting competition and protecting consumers are complementary. And she's been outspoken about the growing threats to competition and the abuse of consumers' data. She's championed merger retrospectives, corrective enforcement, and rulemaking authority. She's advocated for consumers, especially those underrepresented and marginalized, as well as working families and work-life balance. Today, Commissioner Slaughter will be talking about the tools that are available to the FTC. This is incredibly timely. Just last year, the Supreme Court struck down the FTC's ability to obtain monetary remedies, something it has relied on so much in the past. And at a time that the public is clamoring to do something along the lines of antitrust law, and the FTC sees at least this one tool taken away, the question of what tools are available to the FTC is one that is incredibly important. Without further ado, Commissioner Slaughter.
Thank you so much, Professor Carrier. And before I begin, let me apologize to all of you for my lateness. The train was delayed. I'm out of practice, leaving the house, going places, talking to people. So I hope you'll bear with me as I get into this conversation, which I think is really important and really exciting to have. So again, I want to thank you, Professor Carrier, for that kind introduction, and to Rutgers Law School for hosting me and inviting me to deliver the Greg Lastowka Memorial Lecture. Professor Lastowka was a beloved member of the Rutgers faculty and an all-around wonderful human being who was taken from our world far too soon in 2015. I didn't have the privilege of knowing him personally, but I do know him as an accomplished scholar in cutting-edge areas of the law. The names of two of his best-known articles, The Laws of Virtual Worlds, written in 2004, and Virtual Justice, The New Laws of Online Worlds, written in 2010, say it all. He researched and explored novel issues surrounding virtual property and avatar rights, and the potential legal challenges that could arise in online spaces, all before smartphones, tablets, and other technology that we use on a daily basis came to market. He was a trailblazer in cyber law. He explored its intersection with intellectual property law and specifically trademark law, issues that the FTC specifically grappled with in its antitrust case against 1-800-CONTACT. The rich legacy Professor Lastowka left behind makes it an enormous privilege to be chosen to deliver today's lecture. I will attempt to honor his trailblazing by treading some new ground of my own regarding antitrust law, an area of the law which, until a few years ago, was a bit sleepier than cyber law. Today, I'm going to share my views about how competition enforcers like the Federal Trade Commission can best meet this historic moment in antitrust law and perhaps channel some of Professor Lastowka's cutting-edge approach to our 20th century antitrust statutes, as well, I hope, as his sense of humor. So with that, I want to begin by grounding our conversation in a cultural trope that is frequently applied to antitrust law, the 1987 cinematic classic, The Princess Bride. Let me sum up. No, it is too complicated, let me explain. Perhaps not everyone watched The Princess Bride and thought of antitrust law, though everyone should watch The Princess Bride. If you haven't, you're 35 years behind and it's time to catch up. For the few and far between among you who did not enjoy the movie, apologies in advance because we're about to go deep. And for both of you in the audience who don't yet know the story, it is the tale of a farm boy, Wesley, who leaves his true love, Buttercup, to seek his fortune. After he has been gone for some 5 years, Buttercup is betrothed against her will to the evil Prince Humperdinck. Wesley disguises himself as the man in black and sets out to rescue her from her impending nuptials. Along his quest, he aligns himself with Inigo Montoya, a Spanish swordsman, who has a vendetta against Humperdinck's top lieutenant for killing his father, and Fezzik, a giant who is loyal to Inigo. Towards the climax of the movie, our triumvirate of good guys are preparing to storm the castle, rescue the princess, and avenge the death of Inigo's father at the hands of Humperdinck's lieutenant. They take stock of the task ahead, assessing what they have to do and what liabilities and assets they have in the fight before them. And that is what reminds me of this moment in antitrust law and how I'd like to use my time this afternoon to describe what I see as the task before us, assess our liabilities, and explore the full panoply of assets we have to accomplish our mission. And specifically, I want to discuss some statutory tools that have been sitting in front of us unutilized for far too long. So, back in the movie, Wesley is revived from being mostly dead, and Inigo lays out the task ahead. He explains, all we have to do is get in, break up the wedding, steal the princess, and make our escape after I kill Count Ruben. Wesley astutely observes, that doesn't leave much time for dilly-dally. As antitrust enforcers, we have a mighty task before us. It is clear we have a concentration and competition problem in many industries throughout our economy. With fewer choices and slower innovation, consumers and workers are squeezed while firms extract high profits with little risk of competitive forces disrupting the status quo. As the 20th century came to a close, companies unleashed a merger wave that continues unabated to this day. By one assessment, the number of mergers consummated each year between 1985 and 2017 in the US rose from approximately 2,000 to 15,000. And the subset of mergers that companies were legally obligated to report to the FTC and the DOJ's antitrust division has expanded at similarly staggering rates. In fiscal year 2021, for example, approximately 3,600 transactions were reported. That's about 87% more than the average number of transactions reported over the prior 5 years, and 2.5 times more than the approximately 1,400 that were filed a decade earlier. Meanwhile, the number of employees the FTC has to review all those filings remained effectively flat. A large body of evidence shows that concentration levels within industry sectors is high and has continued to rise over time. We can fairly debate individual studies and how they inform antitrust policy, but the weight of this empirical evidence cannot be ignored. One study of approximately 900 industry sectors concluded that market concentration increased by 75% between 1997 and 2012. And within those sectors, the market share of the top 4 firms increased by over 25%. Far from leading to increased efficiency, as some commenters claim, these high rates of market concentration have led to increased market power among fewer firms in myriad industries. Indeed, this enhanced market power has been characterized by significant rises in markups and profit margins, but notable decreases in output and productivity growth. Digital markets are a key concern, and I'll address them further in my remarks this afternoon, but the scourge of market power reaches far beyond big tech. We have all felt the impact of market power in our daily lives, from cell phones and broadband, to healthcare and pharmaceuticals, to the food in our refrigerators, and beyond. There is no doubt that high market concentration and unchallenged market power of dominant companies in our economy inflicts serious harm on competition, consumer choice, product quality, innovation, and workers. These distortions heighten exclusionary barriers that small and nascent businesses face, as dominant firms have constructed moats around the suppliers and customers rivals might need to grow. Because they are insulated from the threat of losing customers to rivals, dominant firms also degrade products and services, and there are strong disincentives to invest in assets or R&D. Within supply chains, incumbents exploit their position as gatekeepers to dictate commercial terms and to extract concessions their business partners would not otherwise agree to under competitive market conditions. And in labor markets, these forces deprive workers of a competitive process for their employment, stagnate wages, and inhibit their mobility. For example, through the proliferation of non-compete clauses in employment contracts and anti-poaching provisions in franchise agreements. So, bringing us back to the Princess Bride, we need to storm the castle, and we don't have a lot of time for dilly-dallying. In hatching the plan to rescue Princess Buttercup, the first thing the Man in Black does is ask for an accounting of liabilities. Inigo reports that they face a castle that has but one gate guarded by 60 men, while they are a team of only 3, one of whom is just recently mostly dead, though a quick healer. That analogy resonates. Competition authorities, including the FTC, the DOJ, and our state counterparts, are vastly outmatched by the parties whom we investigate and against whom we litigate. As I mentioned, our staffing and funding levels have remained relatively flat, while our workload, as measured by the number of merger filings and level of concentration in the economy, has grown dramatically. And on top of that, we are grossly outnumbered on each specific case we bring. It is not uncommon for there to be a dozen or more attorneys representing the parties we investigate for every one FTC hearing. Our entire annual budget in 2021 for all of our operations, including all of our consumer protection work, all of our competition work, was about $351 million. That is an unfathomable amount of money to me as a human, but I did the math and it turns out that that is approximately how much profit, not revenue, profit, that Facebook, a company we are currently suing for antitrust violations, makes in a day and a half. But the David versus Goliath feel of our work is not our only liability. The courts have substantially tied our hands as well. Professor Carrier mentioned one pretty devastating decision, and right now there's a challenge before the Supreme Court to our authority to litigate cases using the administrative process Congress designed for the agency. Over the last several decades, antitrust enforcers have been hamstrung by court decision after court decision that take limited views of the antitrust statutes and, I think, betray congressional intent. This body of jurisprudence is so permissive that it incentivizes companies to continue proposing anti-competitive mergers and engaging in anti-competitive conduct. Many of these decisions require congressional action to correct, and I think the agency should be candid with Congress about how antitrust laws could be improved to help us more effectively and efficiently prevent and stop anti-competitive mergers and conduct. I could give an entire lecture on potential changes to the antitrust laws, but as enforcers, we cannot simply sit by and wait for Congress to send reinforcements in either money or authority. We need to assess the assets we have today and how we can more vigorously enforce antitrust laws within the existing statutory confines. So, back at the castle gate, the Man in Black catalogs the assets available to save Princess Buttercup. Inigo reports that those assets are your brains, physics strength, my steel. Wesley immediately responds, that's it? Impossible. He knows that those tools alone are not going to get the job done. And like the team in The Princess Bride, we have some important assets that are really valuable that we know how to use. Among these, at the top of the list, is our dedicated, creative, and expert staff who figured out how to investigate, litigate, and win certain types of cases with enormous effect. Some highlights of effective enforcement include our hospital merger program. In the last 2 years, we've brought 4 challenges to proposed hospital mergers. 2 of those abandoned in the face of commission challenge and 2 litigated. We just had an important Third Circuit victory in one of them last week. And there was an additional case in which the hospitals abandoned their merger before the commission voted. In the pharma space, we've gotten really good at identifying and requiring divestitures of product and product pipeline overlaps in pharmaceutical mergers. Our staff has also pioneered successful litigation against illegal pharmaceutical settlements, in which brand companies pay to keep generic competitors out of the market. I'm also extraordinarily proud of our team's trial victory against pharma bro Martin Shkreli earlier this year for his anti-competitive price hikes on the vital drug Daraprim. Moving beyond healthcare, I'm proud to note that in the last year, while the Commission has been at a 2-2 deadlock, we brought 3 full-on challenges to vertical mergers, resulting in 2 abandonments. 3 years ago, when I settled on what I felt was an inadequate settlement of a vertical merger case, many would have found even a single vertical challenge, much less 3, to be entirely inconceivable. And of course, we filed a landmark case against Facebook. We've also challenged multiple nascent competition acquisitions in commercial goods like razors. There is much work to be proud of out of each of our competition shops. But, sadly, this work is not enough. For each of these examples I've touted, I could add a caveat. Additional counts we could have pleaded, or mergers we didn't challenge, or theories we could have pursued. Even our Facebook case can have the feel of a land war in Asia. It's going to take years to even get to trial. And the fact remains that the merger wave and consolidation continue, notwithstanding the valiant efforts of our staff. It's clear that the assets we've been using alone are not getting the job done in fighting back against the tides of monopoly power. So back at the Princess Bride. Daunted by the limitations of their personal skills, however impressive, the man in black wishes for a wheelbarrow and a cloak of flames to help plan the castle assault. And lo and behold, he has access to both. His team just hadn't been thinking of them as assets. Similarly, I think we can scrutinize our own toolbox and identify assets available to us that may have gone overlooked. This has very much been the approach of the Biden administration. Last year, President Biden called on all federal agencies to take a whole-of-government approach to addressing the current lack of competition and the harms that Americans face as a result. It is important to marshal all facets of government in tackling these problems because competition is implicated by policies across the government, not just in competition agencies. For example, the FCC recently initiated rulemaking that would affirmatively open up for competition for broadband in apartment buildings. The FTC, given its explicit remit to address unfair methods of competition, has a particular role to play in the assault on monopoly, and we have some specific tools in our own toolbox that we can dust off. Some of these include, first, our authority under Section 5 of the FTC Act to block unfair methods of competition that do not fall squarely within other antitrust statutes. Second, our authority to pass rules under Section 5 to prohibit unfair methods of competition. Third, a cross-agency approach to competition and consumer protection questions. Fourth, underutilized language in Section 7 of the Clayton Act to block proposed acquisitions that would tend to create a monopoly. And fifth, merger guidelines that can be revised to better reflect market realities and improve agency approach. I will touch on each of the first 3 briefly, but I think they've been pretty well covered in other fora, so I will really spend the meat of my time on Section 7 before turning briefly to the merger guidelines to conclude. Section 5 of the FTC Act prohibits unfair methods of competition. This has long been understood to encompass all mergers and conduct that would independently violate the Clayton and Sherman Acts, but it also goes beyond those statutes. Last summer, the FTC voted to rescind its prior Section 5 statement that, in the opinion of the majority of the Commission, including myself, did not accurately reflect the text, structure, or history of Section 5. I won't rehash those arguments here, but I will commend to your attention the full Commission statement on Section 5. Congress intended Section 5 to apply to market power abuses that are not captured by the Sherman or Clayton Acts, and we should use this legal authority more frequently on a standalone basis, such as to go after the anti-competitive use of market power that might not rise to the level of gaining or maintaining monopoly power. I also won't belabor the question of competition rulemaking today. Much ink has been spilled on it, including very articulately by our chair and former Commissioner Chopra. I will only add that I share their understanding of the statutory delegation of rulemaking authority and agree that there are certain types of anti-competitive activity that are difficult to litigate on a case-by-case basis. In these areas, the markets would benefit from clear, transparent ex-ante rules. I put at the top of the list the scourge of non-compete clauses that limit labor mobility and prohibit workers from benefiting from fair competition for their labor. One of the structural advantages the FTC has over our counterparts in other jurisdictions that handle exclusively competition or exclusively consumer protection is that we do both. The issues are connected. Monopoly power allows companies to hurt their users, and sometimes firms try to get or keep a competitive edge by violating consumer protection law. The connection between competition and consumer protection is particularly acute though also complicated in digital markets. Historically, however, we've treated these missions as entirely distinct. There was little contact between our competition and consumer protection staff. And when I got to the agency, I was shocked to find that we would frequently have the same company under investigation at the same time on both sides of the house, with no conversation between teams to identify any connection between the cases. We are already well in the process of fixing this, and I look forward to our continuing to build a whole-of-agency approach to our work. Okay, finally, Section 7. The heart of merger enforcement, Section 7 of the Clayton Act, prohibits mergers and acquisitions whose effect, quote, may be substantially to lessen competition or tend to create a monopoly. For those who follow antitrust litigation and jurisprudence, the substantial lessening of competition prong is very familiar. It has been the primary analytical framework we use to challenge mergers. Our cases define markets that are most relevant to the merger and seek to prove whether the effects of the merger may be to substantially lessen competition. Less familiar is the tend to create a monopoly language. I believe this prong is useful to effectuate Congress's clear desire to arrest monopolies in their incipiency when it enacted the Clayton Act. Giving full meaning to statutory text is part of our duty to faithfully execute the laws Congress has passed and fulfill our mission. I will explain why I believe the tend to create a monopoly language may prescribe different mergers than those prohibited by substantially lessening competition, and then talk about what sort of cases I believe that text covers. While there's little recent case law on whether a merger violates the tend to create a monopoly test, that does not mean this part of the statutory text has no legal force. Indeed, one fundamental rule of statutory interpretation, get ready to geek out on the canons here for a second, is the rule against surplusage. As the Supreme Court instructed in Hibbs v. Wynn, a statute should be construed so that effect is given to all its provisions, so that no part will be inoperative or superfluous, void, or insignificant. Here, the importance of that instruction is amplified by the use of the conjunction or rather than and between substantially lessen and tend to create a monopoly. Or suggests that the two phrases are not merely duplicative of each other. Despite the lack of recent jurisprudence around tend to create a monopoly, canons of statutory interpretation require that antitrust agencies, like courts, give full effect to this Clayton Act prong. Statutory interpretation always starts with the statutory text. The Clayton Act does not expressly define the phrase tend to create a monopoly. However, the phrase's keywords, tend and monopoly, have natural language definitions. So like courts, we can refer to dictionaries for guidance when interpreting statutory language. Black's Law Dictionary defines tend as to serve, contribute, or conduce in some degree or way. That dictionary also defines monopoly as the market condition existing when only one economic entity produces a particular product or a particular service. Taken together under a plain language interpretation, a proposed merger would violate the tend to create a monopoly test of Section 7 if the effect of the merger contributes to shifting market conditions away from competition involving multiple firms toward an eventual state where fewer and fewer firms provide a particular product or service over time. The history of the Clayton Act supports this reading. The congressional record of the original Clayton Act of 1914 reveals that legislators intended that the act prohibit attempts at economic concentration before they grew into actual monopolizations that would be prohibited by the Sherman Act. As noted by the Supreme Court, the Senate report accompanying the original legislation provided that the Act's goal is to, quote, reach incipient monopolies and trade restraints outside the scope of the Sherman Act. According to the accompanying House report, the purpose was to, quote, arrest the creation of trusts, conspiracies, and monopolies in their incipiency and before consummation. The House also insisted that substantially lessening competition should not be the only ground for a Section 7 violation, because a merger or acquisition may result in, quote, no lessening of competition, but the tendency might be to create monopoly or restrain trade or commerce. In 1950, Congress amended Section 7 of the Clayton Act to broaden the scope of mergers and acquisitions covered by the statute, but reaffirmed its original goal. For example, the Senate report accompanying the 1950 amendment explained that the amended Section 7 would not apply to the mere possibility, but only to the reasonable probability of the prescribed effect, which is the substantial lessening of competition or tendency to create a monopoly. The accompanying House report further explained that Section 7 would target mergers and acquisitions that, quote, have a cumulative effect toward achieving restraints of trade, which the Sherman Act would otherwise prohibit if such restraints were achieved in one step. This would allow the government to intervene in such a cumulative process where the effect of an acquisition may be a significant reduction in the vigor of competition, even if the competition does not, quote, create a monopoly or constitute an attempt to monopolize. Congress's intention to broaden the Clayton Act through the 1950 amendments was understood by antitrust commentators as well. Citing the same legislative history, contemporary antitrust observers understood that acquisitions that directly resulted in sufficiently concentrated control of a market would already be prohibited by the Sherman Act. The Clayton Act focused on a different path, when a, quote, series of acquisitions would achieve the same concentration or control. Such a series could consist of a range of actions that could collectively reach the end result prohibited by the Sherman Act, though none would likely be sufficient alone to violate the Sherman Act. The legislative history makes clear that Congress intended for the Clayton Act to eliminate the ability of market participants to achieve indirectly, through a series of mergers and acquisitions, the level of market control could not be achieved in one distinct merger or acquisition. And in the wake of the 1950 amendments to Section 7 of the Clayton Act, courts also recognized that Congress intended the tend-to-create a monopoly tax to be employed as a tool to stop in their incipiency mergers that threaten to enhance the market power of a few firms. For example, 8 years after the amendment, the District Court in United States v. Bethlehem Steel enjoined Bethlehem Steel, the second largest firm in the iron and steel industry, from acquiring Youngstown Sheet and Tube Company. The court found it significant that Bethlehem had grown from possessing 6.3% of industry ingot capacity to 16.3% over the course of 38 years, largely due to a series of mergers and acquisitions. The court then found that adding 5% to Bethlehem's 16% of industry capacity would not only intensify the existing concentration in the industry as a whole, but would increase unduly the concentrated power in the big two, as against the reduced number of an already severely limited group. And this is an important quote. It is clear that the kind of further concentration in an oligopoly framework that Congress was concerned with tend to create a monopoly clearly includes aggravation of an existing oligopoly situation. So what types of mergers today might be covered by the tend to create a monopoly test? I can think of at least 3 categories of cases to which this language might be applicable: serial acquisitions, adjacent market or conglomerate acquisitions, and acquisitions that plan to take assets out of the market. And to be clear, many of these types of cases may also be barred by the substantially lessened competition prong. I am not suggesting that language would be inapplicable to these patterns, but I do think these types of cases are especially well suited to consideration under tend to create a monopoly. A common thread across dominant firms that now control many industries is a history of aggregating significant market share over time by acquiring a series of smaller rivals, some of whom may have posed nascent or future competitive threats. 3 totally distinct examples of this phenomenon across the economy are digital markets, dialysis services, and eyewear markets. Both the FTC and the U.S. Antitrust Subcommittee in the House have studied the ways in which small serial acquisitions contributed to the dominance of tech giants. Both of these studies documented the ways in which large tech giants got large, in part by executing hundreds of small mergers, gobbling up rivals, potential rivals, or new products in adjacent markets, as well as assuming the talent of competing executives and entrepreneurs. But this problem is not cabin to tech. There is strong evidence that small serial acquisitions are a driver of market power problems in American sectors outside of digital markets. The dialysis industry, for example, is also afflicted. One study observed that 4,000 acquisitions of kidney dialysis centers were proposed between 1997 and 2017. As a result, the dialysis industry consolidated significantly over the last 2 decades. In 1997, 2 firms controlled 31% of dialysis centers nationwide. By 2016, 2 firms controlled 77% of those facilities. And by 2018, their combined market share increased to 92%. The retail eyewear industry is also a worrying example of how serial acquisitions enable the exercise of market power. One study has shown that the 3 largest firms in that industry possessed a combined 61% market share, with one dominant firm controlling 40% of the U.S. market. That firm's path to market power in the U.S. began with its purchase of the parent company for LensCrafters in 1995. Since then, it has gone on to acquire myriad other eyeglass retail stores, as well as frame brands, a leading vision benefit provider, and the largest maker of prescription lenses and contacts. One commenter aptly captured the scope of the dominant eyewear retailer's market power. Just imagine you go into a lens crafter's retail outlet, where the salesperson shows you these frames under various different brand names, and then the company pays itself for the lenses it also owns when you use your iMed insurance. In each of these industries, many of these acquisitions were too small to be noticed under HSR. But even if they had been noticed, they might not have triggered antitrust attention under the substantially lessened prong of Section 7. But it cannot be that the law allows a company to acquire and maintain monopoly power using a death by 1,000 merger strategy. I believe we should look at the competitive backdrop of an industry under substantially lessened, but I also believe this is where tend to create a monopoly can come in, to allow us to capture and enjoin mergers that contribute to shifting market conditions away from atomistic competition to monopoly control. The second type of case where the tend to create a monopoly language of the Clayton Act would apply is adjacent market or conglomerate mergers. By this I mean cases where a company develops market dominance by acquiring companies to which it has no existing vertical or horizontal relationship. These acquisitions can facilitate a firm's ability to foreclose or exclude competition in the future by locking its users into its own ecosystem. In this way, adjacent acquisitions tend to create a monopoly. They contribute to the consolidation of market share among fewer and fewer firms over time, even if it is not apparent that the effect of each acquisition may be to substantially lessen competition. Google is an example of a dominant firm that has used adjacent acquisitions to enhance and entrench its market power. From modest beginnings as a mere search engine in 1998, Google's popular web browser, email, map, and meeting software are used by billions of people today. Google expanded its ecosystem beyond search through multiple acquisitions in markets such as publishing, editing, images, video, office tools, AI, and cloud computing. However, the source of nearly all of Google's profits now come from advertising. Google first broke into the advertising world with its acquisition of the digital market technology service provider DoubleClick in 2008, and has grown to be the most dominant player in online advertising. According to eMarketer, it has a 37% share of the $130 billion US digital ad industry and closer to 80% of US search ads. The scope and scale of the ecosystem that Google has built today is breathtaking, but driven in no small part by its scores of acquisitions it made since 1998 in markets adjacent to its search engine roots. The final type of acquisition I want to talk about is one where the acquiring party intends to degrade or remove its target from the market. In particular, I'm thinking about acquisitions by private equity firms in which the goal of the merger is for the acquirer to extract value from its target, not by operating the asset and competing, but by executing a roll-up strategy. Driven by a singular goal of extracting outsized financial returns for themselves and their investors, this strategy typically entails loading up the acquired company with unsustainable debt and selling its real estate and other component parts. This is not something our current antitrust theories contemplate. We assume a profit-maximizing goal, which is realized by competing, not by exiting a market. But imagine a duopolistic market in which a PE firm buys one of two existing competitors in a debt-financed transaction. The acquired firm goes bankrupt, the PE owner sells its component part and exits the investment having made a profit, and the defunct firm is no longer competing. The effect of that transaction is to create a monopoly in the market, even though the merger of the PE firm and the target does not, by itself, substantially lessen competition because the PE firm was not previously competing in the market. An example of increased market concentration and harm to consumers that PE roll-up strategies cause can be found in the retail grocery industry. Between 2015 and 2018, for example, 7 major US grocery chains filed for bankruptcy, and all did so after private equity firms acquired them and because the firms executed roll-up strategies. Southeastern Grocers is one of these 7 retail chains. Southeastern consists of the Bilo, Fresco y Mas, Harvey's, and Winn-Dixie brands. Using high levels of debt, PE firm Lone Star acquired Bilo in 2005 and drove the company into debt by 2007. After Bilo emerged from bankruptcy, Lone Star saddled the company with more debt to pay itself. For example, Lone Star used $458 million of a $475 million loan to pay dividends. Lone Star also kicked its roll-up strategy into high gear by using debt financing to acquire Winn-Dixie in 2012 and Harvey's, Sweet Bay, Reed's Piggly Wiggly stores in 2013. Driven by Lone Star's thirst for outside returns and unsustainable debt payments the chains now own, Lone Star sold the distribution center for $100 million and used a sale-leaseback maneuver to sell numerous stores for $45 million and required those stores to pay rent moving forward on the property they used to own. And Lone Star extracted $980 million in dividends from the Southeastern chains between 2011 and 2018. Unsurprisingly, Southeastern filed for bankruptcy in 2018. In order to exit bankruptcy, Southeastern closed 94 stores and fired 2,000 workers in its surviving stores. And I just want to take a moment to think about, we're talking about groceries, which real people need to buy every day. It's not a luxury good, it's not a choice, and the effect of food deserts is something that we see particularly in marginalized communities around the country. So we can get into the weeds on all of these economic theories and sections of antitrust law, but at the end of the day, we're talking about the effect on real people and their ability to access the things they need for everyday life. And I want to make sure we never lose sight of that in these conversations. These kind of roll-up PE strategies tend to create monopolies in the remaining markets, and we should be able to prevent them. So with all of this groundwork, I want to turn to the final tool in our toolbox, the merger guidelines, which are not formal rules, but set forth the framework, methodology, and enforcement policies that guide our review of proposed mergers. This is not a new tool for the agencies, but it is one that could be substantially updated in order to give more accurate effect to our current statutory framework. The FTC and Department of Justice's Antitrust Division are already in the process of revising our joint merger guidelines. On January 18th, both agencies issued to the public a request for information as part of this revision exercise. The RFI expressly tells the public that the review is being undertaken to ensure our merger guidelines reflect current learning about competition based on modern market realities, and faithfully track the statutory text, legislative history, and established case law around merger enforcement. And in that vein, one of the first sets of questions in the RFI goes to the heart of the concerns I've discussed this evening about the rise of market power abuse despite the best efforts of our talented staff, and the need to reimagine our historically underutilized tools. It asks, do the guidelines reflect any additional competitive concerns reflected in the Clayton Act's prohibition against mergers that, quote, may tend to create a monopoly? Is this statutory language directed at preventing monopolies in their incipiency, such as through serial acquisitions, including roll-ups? How should the guidelines address a merger that may tend to create a monopoly? How should the guidelines analyze whether there is a trend toward concentration in the industry, and what impact should such a trend have on the analysis of an individual transaction? The current deadline for public comments of the merger guidelines revision RFI is April 21st, 2022. You all are well positioned to tell us about abuses of market power in industries that are near or dear to you, especially when those abuses are in their incipiency. So I encourage you and everyone to submit comments. Doing so will help us strengthen our enforcement of the antitrust laws to meet the challenges of modern market realities. So finally, I will conclude this lengthy tale by coming back to the Princess Bride. Though their escapade is not without substantial setbacks and surprises, the Man in Black, Inigo, Fezzik, and Princess Buttercup do manage, against all odds, to best Prince Humperdinck, kill Count Rugen, and escape. To get that happy ending, they need to stay persistent, think creatively, and work with relentless determination. Over the nearly 4 years I've been a commissioner at the Federal Trade Commission, I have been working to do just that, and I think it's the perfect place for such an endeavor. I have enormous gratitude for the hard work that our dedicated and talented staff have done and all they've accomplished. And I also appreciate what I've heard over and over from them and from my predecessors. The FTC is special because it is an institution that is committed to self-reflection and that has a strong willingness to adapt to changing market realities in order to tackle tough problems. In fact, these concepts were at the very heart of the creation of the FTC. Congress was unhappy with the status quo in 1914. Antitrust law and the Department of Justice were not sufficiently tackling the market power problems of the day. And as a result, Congress established the FTC to further protect consumers and promote competition in the face of anti-competitive, deceptive, and unfair business practices. We have a mighty task ahead, and we may be outmatched. But notwithstanding the challenge, the battle is worth fighting with every asset at our disposal. So I thank you for your time today and hope you have Have a wonderful rest of your afternoon.
Thank you so much, Commissioner Slaughter, and we do have time for questions.
Go ahead.
Hi, thank you, Commissioner. Me?
Yeah, you go ahead.
So, first of all, thank you for the movie-driven analysis. It's close to my heart. I used to use my cousin Vinny in class.
Oh, that's a good one.
It's a good one to extract a lot of truth about life, so it really made me feel good to hear you. It was masterful, thank you. So, now my question to you, as I hear you talk about really the government as the underdog and looking for assets, which I really appreciate all of those that you described. How much do you work with foreign agencies? Do you have any formal mechanism? Because I imagine that they have the same problems. The companies operate in Europe, I'm sure, in the same manner as they do here. And historically, the European antitrust agencies were kind of thinking that the U.S. overreaches with the extraterritorial effect of law. But it seemed to me that it would be a great time and a great set of common problems to tackle together, if only because it might give additional leverage and bring more troops, so to speak, right? To the
Yeah.
So I don't know if you do it or if it's in the cards.
It's a great question, and I will answer it in several ways. The answer is yes, we do work with our counterparts in other jurisdictions. We work with them both formally on specific cases and informally, building collaboration, communication, and learning from each other. You know, we do have slightly different tools. They enforce different laws than we have here. They have different remedial power. But a lot of the markets that we're dealing with are global. A lot of the companies are operating globally, and we can, in fact, leverage those tools more effectively when we're working together. I will give you another analogy from literature, not film. One of my children's favorite books is a book called Swimmy the Fish, which is a 1970s classic children's story about a little fish who goes, it's a little dark at the beginning, a little fish goes out to swim and his whole family gets eaten by a school of tuna. It's very depressing. And Swimmy the Fish is all alone in the sea, and then he goes and finds this other school of fish that are all hiding in the shadows. And he wants them to go out and play, but they are afraid of also getting eaten by a school of tuna. So what he does is teach them to swim in formation so that together they look like a really big fish, and they can use that to scare the big fish away. I think about that all the time when I think about our collaboration with other enforcers, whether it's state AGs or foreign counterparts. I think it's enormously useful. It does give us leverage. It also gives us learning. And some of the ways the learning is useful is not just to collaborate on specific enforcement, but to learn about what problems we have that are the same and what are distinct. And so I'll give you an example. I was talking to a counterpart in Germany last week who was mentioning their concerns, shared concerns about digital market concentration. And he said, but you know, in other areas in Germany, we have a pretty competitive market. We're really not worried across the board, because I was saying that I am worried not just in digital markets, but in many markets here. And it was really interesting to hear about Germany's experience, how they ascertain that, how they monitor it, why they think that that's the case. And I think that that can be really instructive to us as we consider what tools we have, what tools we need, and how our markets are operating.
Thank you. Thank you very much.
You're welcome. Ellen, go ahead.
So one of the things you've written about is the relationship between democracy and the curse of bigness, as Brandeis put it. And I think modern antitrust has kind of overlooked and neglected that aspect of it. And I think you can clearly see in your food security example or what private equity has done to journalism, sort of the relationship there. I wonder also, though, whether there is a tension in that argument. And so, for example, Mark Zuckerberg, when faced with critiques of Facebook Meta, has said, it's she or me. Like, if you want to live in a democracy and you want digital companies that are subject to democratic control, you should pick me. And I think I've also heard that argument in connection with the private sanctions on Russia, right? That if we had fully decentralized, Bitcoin and et cetera, cryptocurrency and other kinds of decentralized technologies, they would not walk lockstep and sort of do the good things that we want that democracies want them to do. So I just wondered if you could reflect on that.
Yeah, it's a great question. I think of this argument as the "but China" argument. I hear a lot of arguments that are sort of throw out a term that is meant to scare you from engaging in the argument because the term is itself so scary. So, but China, but AI. You know, you can't answer because this thing is so compelling. I don't think that's true when you unpack it. I will share that before I came to the FTC, when I worked in the Senate, among the work I did was in national security. So I'm actually really sensitive to national security concerns and the intersection of some of these issues with national security. And I think China, Russia is a very handy foil for companies that don't want to see competition enforcement in the United States. But the answer to national security concerns is not monopoly. Monopoly is a national security concern in and of itself. There is a saying in the national security space that if you have two, you have one. If you have one, you have none, right? Because if you have a vulnerability and you have limited supplies, you're in really big trouble if your system gets compromised. This is why we diversify financial assets, right? This is a principle that is across the board in how we think about things. The argument that if we don't take American monopolies, we are left with national security threatening Chinese monopolies doesn't seem to follow to me. I also think it is the case, just as I think when American companies choose to operate in Europe, they subject themselves to the laws of Europe. And if those laws are changing, as they are, in ways that, that restrict dominance, including by American companies, that's the price you pay when you sign up to make money in Europe. I similarly think when companies sign up to make money in the United States, they sign up to subject themselves to our laws. So I am as concerned about monopoly power in a foreign-owned country operating in the US as I am about monopoly power by an American company operating in the US. The concern is monopoly power. I think I saw you, and then here and here.
So just a question about your discussion of Section 7 and the tendency to create a monopoly. You said it's an underutilized tool, an underutilized language. And could you just explain why you think it has been largely overlooked? Is it that tendency seems speculative?
I don't know what the why is. I will tell you that when I first started floating this, people are like, well, monopoly. So to prove a violation of the Sherman Act, Section 2, you have to show that a company has monopoly power. And I think people really hang on to the idea that monopoly is the operative word in that prong, and proving monopoly power is really hard. But that totally reads out the tendency language, and that's the one that I hang on to. What does tendency mean that is different from the other portions of it? There may be a good reason that I have not yet uncovered why we haven't pursued this, and it may be that if we try, it hits a brick wall, but I'm for trying. I'm for trying different things, seeing how it goes, as I said, making the case to Congress for when courts are misinterpreting statutes, but I certainly think just leaving a statute fallow is not the right answer, or if it is, I haven't heard a good reason why it should be the right answer yet. Yeah, go ahead.
One thought that I had was that, you know, considering the various powers and authorities given to the agency by statute is always important, but being mindful of things like the Federal Trade Commission Improvements Act, which is an interesting title for that statute, when the Commission uses some previously dormant powers and Congress says, well, we didn't really want you to have that power, and then it doesn't repeal the authority, but simply makes it impossible for the Commission to spend any money to exercise that authority. And they collected together several things that they thought that the Commission was doing on their trademarks or their specific investigation of the food industry, but you're familiar, I'm sure. So if you want to embark on this adventure of using latent authority to achieve goals that we face, maybe I should say to deal with problems that we face in 2022, what do you think the Commission has to do and can do to avoid seeing the Federal Trade Commission Improvement Act in 2022?
This is a great question. It's one that comes up a lot because for those not familiar with the last half century of history of the FTC Act, the FTC was very active in the 60s and 70s and was largely gutted under the Reagan administration in terms of funding, in terms of staffing, with statutory limitations.
In fairness, Ronald Reagan wasn't president in
That's true, but at the end of the Carter administration and through the Reagan administration as part of a big deregulatory wave, it's where we got the Federal Trade Commission Improvements Act legislation, Magnuson-Moss Warranty Act that, among other things, gives us rulemaking power that has substantially more procedural steps and is viewed as substantially limited compared to the Administrative Procedures Act rulemaking power that our sister agencies, and I think we enjoy it. And so the question comes up a lot. Aren't you afraid of blowback? What last time you became the national nanny state, you got gutted. Aren't you afraid of doing that? I think that we need to be very grounded in empirics, in evidence, in facts on the ground. But I think a tool that we don't use, we might as well not have. So if Congress thinks we haven't used the tool appropriately and they want to take it away, we're not really differently off than if we hadn't not using it at all to begin with. I also think that there is a very healthy sense, a vibrant narrative about pushback against the FTC for overreach, and I think it really discounts the pushback that we have gotten and are continuing to get for underreach, which is where we have been for the last several years, and we are at a different moment economically than we were at the time. We're at a different moment in terms of market concentration. We're at a different moment in terms of the intersection of consumer protection and competition. And so the long way of saying that is I am aware of the specter of blowback, and we are always sensitive to that. It has been my experience that it often comes from groups or well-funded groups or companies that are particularly uninterested in having laws enforced against them, and we need to be pretty open-eyed about that. And I will give you an example. Professor Carrier mentioned this horrible Supreme Court decision that took away our ability to give money back to consumers who have had it illegally taken from them, and the Chamber of Commerce is actively lobbying against the restoration of that authority. They argue fine to get money back from like small ball fraudsters who are just outright stealing money, but when large companies lie about what they're doing, that shouldn't result in remediation. But I think large companies should be held accountable for their lies too. So, we see where the opposition is coming from. We have to push back against it, and I think the best way we do that is just being honest about what we're trying to do, why we're trying to do it, be transparent, engage in a conversation. And there's no secret project at the FTC that people don't know about. I've been very transparent about what I want us to do. And as a result, Congress has, over the time I've been at the FTC, increased our funding rather than decreased it. And the pushback, what we hear from them is, we still want you to do more. We want you to break up big tech companies. We want you to study pharmacy benefit managers. We want you to fix gas prices. So right now I'm still in a worried about doing too little rather than worried about doing too much place. But I acknowledge that that history is there and we should be aware of it and learn from it. I think I was going to give you and then right back to you.
Okay, perfect. This might be a simple question, but forgive me. You mentioned the scourge of restrictive covenants in employment contracts earlier, and I'm curious about the assets that the FTC has in its toolbox to maintain market competition for labor and the significance of that.
Okay, first of all, simple questions can be the best questions. Secondly, not a simple question, but a really important one. Labor markets have gotten a ton of attention in antitrust law recently, as they should. Labor is an input for which there is a market, but it is an input that is unlike ingots, because labor carries with it so many other considerations, or compensation for labor for individual people. And so I'll give you the example of healthcare. Labor mobility can sometimes be limited without a non-compete clause because they don't lose their healthcare. We tie in this country healthcare to jobs frequently. So it is a different market in some ways than other inputs, but also an input market, and we have a lot of experience dealing with input markets. We need to pay attention to them. And 2 weeks ago, we challenged a hospital merger, one of those hospital mergers that I mentioned, and Chair Khan and I wrote a statement saying we were glad to challenge it, supported the challenge. We would have also brought account in that case challenging the merger on the basis that it substantially lessened competition in the market for nursing labor in the markets that were affected. the staff, what you can tell from that statement is that we investigated the labor market. That's a big deal. We haven't always investigated labor markets. And that we thought the evidence supported a count in that area. Other things that we can do, and the thing that I referenced in my comments, is I think a lot about non-compete clauses. I find them very troubling, to put it mildly. I think if somebody wants to pay you more or give you better working conditions for your labor, they should be able to do that. And if you're not going to go, it should be because you're getting well compensated for the job that you have. People should get the benefit of fair competition for their labor. So what tools do we have to address it? I will back into that question by explaining that we have rulemaking and we have enforcement and we have market study tools. We could study what's going on with non-competes. I'm not sure that's the best use of our time because a lot of people have done that. Pretty clear they're everywhere. We could bring enforcement actions challenging the application of non-compete agreements as unfair methods of competition or as an unfair act or practice, I suppose. Or, as I mentioned, our chair and former Commissioner Chopra have written about the ability to use Section 5 rulemaking, APA procedures to issue rules against unfair methods of competition under Section 5. This is a topic that we've been asked to consider a rule on, and I think it's right for that consideration. We cannot, by rule, make illegal something that would otherwise be legal. We can't just pass rules that make things illegal. We can only pass rules that clarify up front what conduct constitutes an unfair method of competition. So if we believe, and if evidence supports the idea that non-compete clauses are an unfair method of competition, we could pass a rule saying, prescribing them in some capacity. That rule would still then have to be enforced on a one-off basis. And we've seen in California, I believe, basically ban non-compete clauses. Many companies still employ them. That ban is only effective if it's enforced. They're not enforceable against people. That was the effect of the California ban. It didn't say you couldn't have them, but you can't enforce them. But individual workers don't always know that. That requires a lot of high information and high confidence conduct by people who are in some serious power asymmetries. So I think federal government action is warranted, and we have to think about what the most effective way to do that would be. Yeah, go ahead.
So it seems like yourself and probably most people here have a sort of worldview that society is better off with competitive industries. Are there instances where that isn't the case because things are a natural monopoly? And the example for me that comes to mind is like internet and TV service. You know, I have one choice. It's Comcast. I sign a 2-year contract and they up the price, and you have no, you know. Are there instances like that are natural monopolies that antitrust really isn't even the best place, that they should just be taken into public ownership, or that there's some other
So it's interesting to me that you think of internet as a natural monopoly. The provision, who gets to provide broadband to your building, is a function of local rules and permitting, and it is certainly legally possible for multiple companies to provide internet to the same building and compete down price or compete out service. I will tell you, I was thrilled when I moved to a house where I had a choice between broadband providers and exercised that choice, and I'm very happy with it, and used that choice to play the providers off of each other and get a better deal. Competition totally worked for me there. I think that where this question comes up a lot is in markets that benefit from scale and network effects, right? You can only really compete if you're big enough, and this is where we think about digital platform markets a lot. I am not convinced that the fact that a monopoly is naturally acquired means that it's good for people in the monopoly market. But your question was,
That's not the way that I meant the word natural monopoly. I meant like in the way that like roads are a natural monopoly because we don't want to have
multiple crews.
Things, and so the way that you would provide internet service, to me, it's a natural monopoly, just like electric service, right? I have one provider.
Okay, great. I understand your question better, and I will answer it differently, which is to say, I would like the FCC to reclassify broadband service providers under Title II and exercise all of their more detailed regulatory authority, because I think that it's a critical service that people need. I think this goes back maybe to the all-of-government approach to competition policy, where there are lots of areas where and let me say two things. There are a lot of areas where competition, antitrust enforcement, whether ex ante or ex post, is not going to solve all our market problems. One of the attacks that's lobbied against more progressive antitrust thinkers is the accusation that they think antitrust will solve everything. I don't think antitrust will solve everything, but I think if you don't have competitive markets, you necessarily have problems. I think that if you have competitive markets, you have some of the ingredients necessary for provision of services and goods in a way that is effective and efficient, but different markets are different, and I think we have to combine our skills. The flip side of that is I think policies enacted by other parts of government will affect competition, whether they think about their competition effect or not. And so I would rather all of the agencies be doing an analysis of, okay, how could this rule that seems like a great idea to us affect competition? And so I'll give you one example. It's not other agencies, but when we think about privacy, sometimes people apply as an approach to privacy problems the idea that companies should not be able to share data with anyone upstream or downstream. The effect of that rule may be to only allow companies that are big enough to do all the functionings in a market, payment processing, data and analytics within their own ecosystem. That is privacy protective, competition inhibiting. It doesn't have to be that way, but we need to think about the consequences of policy area A on competition and the consequences of competition back on that policy area. Yeah, Mr. Gary.
So first a quick thought on swimming the fish and how it applied in the farmer growth setting. So as the FTC loses disgorgement authority, you pair up with the states.
This is exactly
$65 million out of farmer growth. That's a benefit of swimming that.
And when I said I think about it, when I think about dealing with state enforcers, that is exactly right. We are now we have always worked well with the states, but we are now really, really working with the states very enthusiastically because they have remedial authority that we don't. We, notwithstanding my complaints about our under-resourcing, are still better resourced than most state AG's offices. And so we have resourcing and investigatory tools that they don't. And we can put these powers together in a way that can be really effective for our constituents at the end of the day.
And then on the proposal, I like the textual idea. I can see a court buying that. And I guess a couple questions are, one is, what about the argument that you're just bringing it now and it's just been so long that maybe courts are a little skeptical of that? A second argument is that we've tried this before in the 60s where we've had mergers that would lead to 5% of the market, and it sounds like this is different, but courts might still be a bit skeptical of that. And then the third is your roll-up strategy. Is that different in kind from the other two? Because you're not focused on the firm itself, you're focused on the remainder of the market. And so to your sense with the roll-up strategy that when the firm is rolled up, that what's left does tend to be.
Yeah, so let me answer the last one. I mean, the PE problem is one that has really plagued me since I got to the agency, because we would look at transactions with PE buyers and you would know from their business plan that their business model is debt finance transactions and exit the market. And so you would know that the result is going to be less competition in the market, but everybody said but that's not, they don't have an asset in that space already, so it's not lessening competition. So that's, it is different a little bit in kind, but a pattern that we see in the markets frequently enough that I think it's worth figuring out how to address. To your question about court skepticism, listen, the courts are skeptical of literally everything we do. The AMG case that you started out talking about overturned 4 decades of precedent from 8 different circuit courts for a statutory interpretation that had been used on a bipartisan basis for 40 years. So So they were skeptical of us doing the same thing we have been doing with the court blessing for decades, and they pulled that authority. So do I think that they're going to be skeptical about new applications of statutory authority? For sure. I think they are I look at every single thing that we do as being met with a skeptical court, which is why I think we have an obligation to make it stand on its face in terms of its value. That's why I want our cases to be the strongest they can be, the clearest, and protect our constituents in the most compelling way, because then we can turn around and go to Congress and say, here's a litany of bad court decisions that you need to fix, or we can find, maneuver through other tools, but at the end of the day, it will not be the argument that we heard all too frequently over the last decade or so, which is enforcers are asleep at the wheel. Like that's what I heard when I came to the FTC. Enforcers have been asleep at the wheel. That's why we have the problem that we have. I think that, as I've said, there are ways we can be more invigorated, but if we are losing, I want it to be because we're trying. The way I put it differently, as a former mentor of mine would say, we have an obligation to seek justice even if we're not guaranteed to achieve it. That is our job, that's the oath I take, and I mean, I'm going to follow the jurisprudence and articulate where I disagree with it, but I don't think we start from the assumption that just because we might lose, we shouldn't give it a try. And I sound very preachy there, but I just feel really strongly about this. I think it's really important. I think it's really important to try. Yeah, go ahead.
Hi. So I am a big believer in progressive textualism, so I was delighted by your talk. And I sort of wanted to probe a little bit further, both whether you see, I mean, one of the things that I found talking about progressive textualism with other progressives is that many progressives are sort of out of the habit of looking directly to text as a source of, legal ideas and jurisprudence, and there's this sort of sense that this is the tool of the right and not of the left. We sort of go with the case law. So I wonder if you think that might be part of the account, perhaps, of why this tool has sort of lain underutilized. And then a second question being, do you view, again, the appointment of self-professed textualist judges to the bench as a potential opening for these types of arguments? Or, again, I know there's often concerns that is simply a political stance, but do you see potential in that? And then the last piece of the argument, curious to know if there are cases where FTC is already using this argument in litigation.
Okay, well, the last question is, we haven't filed any yet, although I did note that in the DOJ's recent challenge to the United, I can't remember what the B-side name was, but they just filed a challenge against the United acquisition a couple weeks ago, and they did cite tend to create a monopoly in their complaint, and I hadn't seen that before, so it totally jumped out at me. I thought it was very cool and interesting. I know this is something Jonathan Cantor cares a lot about. As I noted, it was reflected in the RFI on the merger guidelines, so I am by no means the only person giving thought to these ideas, and I don't want to suggest otherwise. But you haven't seen it in too many cases yet, and we haven't litigated it yet. The questions about textualism. I'm just going to take your questions in reverse order. Yes, I think making textualist arguments is both well-grounded. I think it's makes a lot of sense. I also think it can help us appeal to judges who might not be persuaded by some of the other arguments that might persuade the people who are not currently sitting on the bench. I think the answer to your question of whether it works depends on how cynical you are about judges. It depends on the day for me, but I think if you think that people profess textualism sincerely, then I believe they will take a sincere look at a textualist argument. If you think textualism is a cover for ends-oriented jurisprudence, then no, they're not going to care about it. And there are a lot of judges in this country, so you may get a couple in each of those camps. And then your last question is it that progressives are skeptical of textualism? No, I wish that was the case. I think it's that progressives, as a general matter, have not been running antitrust enforcement for a long time, and I think that part of the backlash to the late 70s, 80s wave has been a much more centrist or even conservative approach. My colleague, Commissioner Wilson, who's one of the Republicans on the committee, both of my Republican colleagues on the committee are really smart and really thoughtful about these issues, and we engage in very spirited debate about these topics. And one of the things Commissioner Wilson says all the time is we don't want to go back to the bad old days of heavy-handed regulation, like with airlines. You know, she uses the specter of the bad old days of airline regulation all the time. I find that argument very unconvincing because I'm like, airplanes fall out of the sky now, and also the experience of flying is miserable. I don't know if you've done it recently. I haven't in a couple of years really, but like I don't think it's probably improved in terms of comfort or convenience or price or efficiency, and there aren't that many airlines competing in the market. So I think that there are good arguments. I think there is this narrative that the 60s, the 70s were necessarily the bad old days that we never want to return to. And I'm not sure that that's entirely true, and I don't think we should accept it as a given. I think we should unpack it and figure out what were problems we do not want to repeat and what are things that we would benefit from reviving. But I don't think we should take as a given that that's where we are. And that actually reminds me that that I wanted to note for Professor Carey's question that some of that going back to 60s conglomerate threshold would have to do with lowering presumptions on market concentration back down to super, super low levels where any increase in market concentration is a problem. I think one of the things I tried to point to is part of what I think the courts and the statute tells us to do is look at the backdrop of an industry and how competitive it is to begin with. So there's a difference between a small acquisition in a market that's already oligopolistic and a small acquisition in a market where you have healthy atomistic competition. So I think that, again, we want to be very precise about what the conditions we're trying to address are. And I will just maybe conclude by saying part of what is great about my job is that it gives me the opportunity to throw ideas out there, think about new directions, and receive pushback and thoughts and engage with disagreement about it, and help move a conversation forward. It doesn't mean that I'm right all the time, or any time really, but I really enjoy getting to advance ideas, and that sort of brings me back to being in a law school, right? That's what you get to do here all the time, and that's an incredible privilege, an opportunity to think through old questions in new ways, new questions, challenge assumptions, and really engage with the world as we have it today against the backdrop of a complicated and important history.
Please join me in thanking Mr. Clark. Thank you so much. Just really phenomenal stuff. So much fun. So